Appear for the petition on this writ petition challenging the dismissal of I number 5, 6, and 7 execution petition. The matter is listed next on 6-9, which is why I'm requesting the writ petition to be listed on Saturday, my lords.
Why?
My lords, the decree holder may take precipitative steps against us, my lords.
It can be on Monday.
My lords,
First is before 6th, right?
I understand, my lords, if may be taken on Saturday.
Monday.
Please,
Give it,
madam.
yes. ಆ ಪಾಸವರ್ ತಗೊಳ್ಳಿ, ಪ್ರಸಾದ ಕೊಡ್ತಾ ಇದ್ರಲ್ಲ.
77.
ನೀವು ಕೊಟ್ಬಿಟ್ಟು ಪ್ರಸಾದ ಹಂಚಕ್ ಹೋಗಿದ್ದೀರಾ? ಹಾ?
I'm apology, my lord. I'm appearing for the petitioner in
Serial
this
number?
case, my lord. 77, my lord. Notifications issued in 88 and 90, my lord.
Okay.
Still possession is not taken, my
Learned
lord.
AGA. AGA na HCGP na. Acquisition, Madam BD. Learned HCGP is directed to accept notice for the first respondent. Counsel Ajay Kumar M is directed to accept notice for the second respondent. Petitioner to serve set of papers upon the aforesaid counsel forthwith lists the matter on 23rd. The petitioner, if in possession as on today, the possession of which shall not be disturbed till the next date of hearing.
Much obliged.
Yes.
Still number 141, let's continue.
The faceless, I'll take the moment I finish this admission matter. Shankar sir. Raghuraman sir is also there in that? Faceless. All right, so that's all. We'll see about that. But I'll hear you both the moment I finish this admission matters. Up to 167 or something. Yes. Chaitanya sir is also there? Ah, yes. Serial number?
141. Ex parte adjudication order.
10,000.
Please.
The petitioner is before this court seeking the following prayer. The heard sounds. The petitioner, inter-alia, contends that he was not heard in the matter and orders have been passed in violation of principles of natural justice. A perusal at the documents appended to the petition would vindicate the submission of the petitioner and indicate that the petitioner was not heard in the matter. The learned counsel appearing for the respondent would, however, dispute the position, contending that though notice was issued, the petitioners have not appeared before the assessing officer. The learned counsel would submit that the petition should be dismissed and not entertained on the ground of violation of principles of natural justice, as the petitioners have not availed the opportunity of appearance when the notice was issued. The order though indicates that the petitioner was not heard, order indicates that the petitioner was not heard, therefore is admittedly an ex parte order. In the light of the dispute with regard to petitioner getting the notices and not appearing before the authority, I deem it appropriate to allow the petition, albeit in part, with imposition of cost of rupees 10,000. Yarak kodak, madam? Oh, sorry. Cost of rupees 10,000 to be paid to the advocate clerk's fund within 4 weeks from the date of receipt of the copy of this order. For the aforesaid reasons, the following order: the petition is allowed, so and so. The stands annexures eno?
Annexure E and F.
A and F.
E and F.
E and F.
Please.
Annexures E and F stands quashed. The matter is remitted back to the hands of the assessing officer to the stage of the show cause notice. The petitioner shall now submit his reply to the show cause notice and the concerned officer shall take the proceedings to its logical conclusion, ordered accordingly. Yes. Cost, yes. Madam.
142.
Madam.
Lord, ex parte order, Lord, without hearing me, an order is passed. There is already
ಯಾಕೆ
one
ಎಲ್ಲ
more
ಹಂಗೆ
order.
ಮಾಡ್ತಾರೆ? ವಾಟ್ ಇಸ್ ಅವ್ರು ಬರಲ್ವಾ, ನೀವು ಮಾಡಲ್ವಾ, ಯು ಆರ್ ಇನ್ ಹರಿ ಟು ಪಾಸ್ ಆರ್ಡರ್ಸ್? ವೈ ದಿಸ್ ಮಶ್ರೂಮಿಂಗ್ ಆಫ್ ಲಿಟಿಗೇಷನ್ ಆನ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆರ್ಡರ್ಸ್?
There's one more order already passed by the superior authority covering the.
ಅಲ್ಲ, ಏನ್ ಎವ್ರಿ ಡೇ ವಿ ಆರ್ ಸೀಯಿಂಗ್ ಎಕ್ಸ್ ಪಾರ್ಟಿ ಆರ್ಡರ್ಸ್? ವೈ?
Address for service.
Ah.
Change their address. So these people would have sent it. Nowadays we send it to portal also or email.
ಹೌದು, ಪೋರ್ಟಲ್, ಇಮೇಲ್. ಇಮೇಲ್ಗೆ ಬ್ಲೂ ಟಿಕ್ ಆಪ್ಷನ್ ಇಲ್ಲ, ಸೊ ಓವರ್ ಅಂತ ಅರ್ಥ. You have to bring in some method where they have received and ತೋರ್ಸಕ್ something should be done. Develop something. Correct. Portal ಅಲ್ಲಿ upload ಮಾಡಿದ್ is a different thing.
We send it, we send an alert message to the number. SMS. ಆ ಥರನೂ ಕಳಿಸ್ತೀವಿ. That is also the-
ಈಗ ಮೊಬೈಲ್ ತೆಗೆದ್ರೆ ನಿಮ್ಮ ಅಲರ್ಟ್ ಅಲ್ಲ, ಬರೀ ಫ್ರಾಡ್ ಅಲರ್ಟ್ ಬರ್ತಾ ಇರುತ್ತೆ. ಮತ್ತೆ ಅವರೆಲ್ಲಿ ನೋಡ್ತಾರೆ?
Petitioner has already participated in another proceeding at the simultaneous time.
ಯಾಕೆ ವೈ ಸುಮ್ನೆ ಲಿಟಿಗೇಷನ್, ಒಂದು ಪೆಟಿಷನ್ ಅಲೋ ಮಾಡೋದು ಎಲ್ಲ. Is it not an exercise in futility? ನೀವೇ ಅಲ್ಲಿ ಕರೆಕ್ಟ್ ಮಾಡ್ಕೋಬಹುದು, ಅದನ್ನ ಇಲ್ಲೇ ಬರ್ಬೇಕಾ ಎಲ್ಲದಕ್ಕೂ?
ಪಕ್ಕ ಚೇಂಬರ್ ಎಲ್ಲ ಇನ್ನೊಂದು ಹಿಯರಿಂಗ್ ಆಗಿದೆ, ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಅಡ್ಜುಡಿಕೇಶನ್ ಫಾರ್ ಮೋರ್ ದನ್ ಅನ್ ಇಯರ್.
Officer, where the assessee should have given at least ಒಂದು ರಿಪ್ಲೈ ಕೊಟ್ಟಿದ್ರೆ ಆಗುತ್ತೆ. ಕೊಟ್ಟಿಲ್ಲ ಅವರು.
ಏನು ಈಗೋ ಸ್ಯಾಟಿಸ್ಫೈ ಆಗಿಲ್ವಾ? ಮತ್ತೆ
That is done by additional commissioner, this is by assistant commissioner. He says there is much more issues which are pending. If at least assessee would have told that
I am before the additional commissioner. You have no coordination between the units of the income tax. ಅದೇ ಹೇಳಿದ್ದು, ನಿಮ್ ನೆಟ್ವರ್ಕ್ ಅಲ್ಲ, ನೆಟ್ಗೆ ವರ್ಕ್ ಮಾಡ್ತಾ ಇಲ್ಲ ನೀವು. Yes. Yes, we will send it back.
to the R1.
First respondent.
Stage of post of
ಒಂದು ನಿಮಿಷ. R1 ಯಾರಿಗೆ? ಅದು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಬರ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. The petition is allowed. The orders impugned so and so stands quashed. The matter is remitted back to the hands of the Assistant Commissioner of Central Tax, the first respondent herein, to hear the petitioner and pass necessary orders in accordance with law. Impugned order. Annexure E and
EFG. So recovery notice ಕೊಟ್ಟಿದ್ದಾರೆ.
ಒಂದೆರಡು ಆಲ್ಫಾಬೆಟ್ ಜಾಸ್ತಿ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. Yes. EFG.
B is the showcase.
ಈಗ ಏನ್ ಬೇಕು?
ಅದು ಅಲ್ಲಿ
EFG ಅಷ್ಟೇ ತಾನೆ? Yes. Next.
143, suppose 144.
Close for the petitioners, my lord.
Page 61 covered,
61, 79, 26.
61 tag,
Chinmay.
64 covered.
79 ಇದೆ, my lord. Chinmay.
Chinmay ಇದೆ. Page?
79.
Page 79.
79.
The petitioner is before this court seeking the following prayer. The petitioner, learned counsel of the petitioner and the respondent would in unison submit that the issue in the list stands answered by the judgment rendered by the coordinate bench in Karnataka Chinmaya Seva Trust.
11154.
ಆಯ್ತು, ಇಲ್ಲಿದೆ ಬಿಡಿ, Seva Trust, which is subsequently followed by the coordinate bench in Madam Annexure F, page 79. So and so, the coordinate bench has held as follows, complete order ಆಗ್ಬಿಡಿ. In the light of the petition standing on the same footing, it deserves to succeed in the same terms that the coordinate bench in Mrs. Karnataka Chinmaya Seva Trust has held.
A and B to be quashed, my lords.
For the aforesaid reasons, the following order. Petition is allowed in part, so and so quashed, matter is remitted by. ಅದರಲ್ಲಿ ಏನಿದೆ ಅದು ಮೇಡಮ್? ಚಿನ್ಮಯ ಸೇವಾ ಟ್ರಸ್ಟ್ ಇದೆ, ಪೇಜ್ 79 ಅಲ್ಲಿ ಇದೆ. ಈ ಆರ್ಡರ್ ಅಲ್ಲಿ ಏನಿದೆ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್, ಅದನ್ನ ಹಾಕ್ಬಿಡಿ.
Oblige, my lord. Great.
ಅಂದ್ರೆ next
145.
Lordship, in this
page
case,
95.
yes,
Yes, 95 covered.
95.
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
ಇಲ್ಲ ಇದೆ, petition ಅಲ್ಲಿ ಇದೆ. ಇನ್ನೊಂದು ಕೊಡಿ. Petition copy.
ನೋಡಿಲ್ವಾ ದಿಲೀಪ್? ಕಾಪಿ ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
Fresh matter. ನೋಡಿ.
ಓ, ಅಡ್ಜನ್ ಮಾಡ್ಲಾ?
ಇಲ್ಲ, it can be stayed.
ತಗೊಳ್ಳಿ, ಕಾಪಿ ತಗೊಳ್ಳಿ.
ಇಲ್ಲೇ ತಗೊಳ್ಳಿ. Right, 3 months, 153.5. Number of orders are there.
ಡಿಸ್ಪೋಸ್ ಆಗಿದೆ. ಏನ್ ಟ್ಯಾಗ್?
Interim order.
ಎಂಟ್ರಿ ಮಾಡ್ರಾ?
Interim order.
Tag this petition along with page 95, sorry.
99 and
95.
100 also. Yeah, 99.
One sack.
Yeah, yeah.
95.
Stay annexure
the-
C and D.
In the light
Further
of the,
proceedings.
in the light of the issue being similar, the petitioner, the subject petition also deserves to be, deserves an interim order as is granted in the companion petition. Tag the petition so and so, lest there shall be an interim order as is granted. Madam, quote the interim order.
C, D and further proceeding.
Quote the interim order. Justice Shyam Prasad ಅವರು quote the interim order page flag ಹಾಕಿದ್ದಾರೆ. Page 95. Quote the interim order and ಇದರಲ್ಲಿ ಏನು annexures ಕೇಳಿದ್ದಾರೆ ಅದು stay ಮಾಡಿ.
Annexure C, D and further proceeding.
Correct. Annexure CD and all further proceedings taken or to be taken thereto.
Page 99, my lord.
One ಸಾಕು sir.
Alla, okay. Yes. Much appreciated.
M. Dilip is directed to accept, ಅದ್ರಲ್ಲಿ ಮಾಡಿದೆ, ಅದಕ್ಕೆ ಕಾಪಿ. M. Dilip is directed to accept notice for the response.
146.
The case of an ex parte order. of
First time
1718.
ಬರ್ತಾ ಇದ್ದಾರೆ. Will direct notice,
Tirumala
dispose it on the next date.
Please.
Learn it. ಇವಾಗ್ಲೇ ಮಾಡ್ಬೋದಾ?
Yes, my lords. What has happened is the board was superseded due to some fraud. It's a cooperative society, house building
Will
society.
post it on Monday and close it.
Please.
Council M. Tirumalesh is directed to accept notice for the respondents. Copy unta?
We have served.
Yes. List on Monday in preliminary hearing. We'll dispose it on Monday.
Please.
Yes.
147.
My lords, in this, there are three prayers.
The refund.
One is a refund. Second one is a mandamus to the CIT to dispose my appeal. Third is so that they don't attach any further refunds.
ಯಾವ್ದು ಬೇಕು ನಿಮ್ಗೆ?
All three, my lords.
ಎಲ್ಲ ಬೇಕಾ?
1213, it is remanded to the CIT. They have not
We'll
disposed
see,
orders.
we'll first take direct notice.
Please, my lords.
ನೀವೇನ ತಿರುಮಲೇಶ್?
Yes, my lords.
Learned Counsel M. Tirumalesh is directed to accept notice for respondents 1, 2 and 3. The petitioner to serve set of papers upon the aforesaid
lords.
counts. Third,
Yes,
copy unta?
Yes.
List on 18th. We'll close it.
my lords. No, my lords, slightly earlier because I have to file my return by 15th. If they process it, they'll attach my refund for the current year.
11th. 11th.
Please, my lords.
Attach. ಅಕಸ್ಮಾತ್ ಮಾಡಿದ್ರೆ ಹೇಳಿ. Yes. Your apprehension comes true andre, then we'll pass appropriate orders.
148.
148 is an import
Custom.
of
140?
148 is import of aracanut, my lord.
Huh.
So first round it was tested by FSSAI fifth respondent and the test report annexure G test report has come out certifying that the goods are roasted aracanuts. Subsequently, the second respondent again sent it to seventh respondent.
Correct.
laboratory.
Plantation crops
Yes, so there
research.
are conflicting reports. In a similar case, earlier this honorable court was directed to send it to Delhi.
We'll send it to Delhi.
Interim order is there in the previous case, my lord.
Other matter is listed on 9th.
9th.
So, which
List the matter on 9th. Learned 2 to 2, 3, 4. Arvind Chavan, Union of India. ಮಧು ನೀವು ತಗೊಂತೀರಾ? ಇಲ್ಲ. Central Revenues Control Laboratory. MN Kumar. Union of India, 1 MN Kumar, 1, 6 and 7 MN Kumar. Petitioner to serve set of papers upon the aforesaid council, if not already served.
But in
9th,
all
9th,
other-
9th, 11th.
Ninth,
Ninth,
but because slight difference is that in all other cases, testing has already been completed.
No, 9th, I think the other bench had granted. We'll take it on 11th.
11th,
Yes.
yes, obliged.
149.
Page 122 covered.
Yes, covered.
Huh? That's what. Page 122, Allah?
Please,
Same.
same.
The petitioner is before this court seeking the following prayer. The learned counsel appearing for the petitioner submits that all the issues in the list have been answered by the coordinate bench in page 122, madam. The coordinate bench has held as follows. Page 124 to. One ನಿಮಿಷ. ಅಷ್ಟೊಂದು ಬೇಡ. 124 to ಬೇಡ. The coordinate bench, on considering every issue raised, has answered them in the following manner. Page 161 in the 160, 167 marked portion. Division bench confirm ಆಯ್ತಲ್ಲ? Division bench ಯಾವುದು?
Division bench ಇಲ್ಲ.
ಮತ್ತೆ ಇದು ಯಾವ್ದು ಹಾಕಿದ್ದೀರಾ ಇಲ್ಲಿ?
Single coordinate bench.
ಅಲ್ಲ, page 168.
Division bench, actually we sought leave to withdraw the appeal pending interest.
Fine, no. In the light of the issue standing answered by the coordinate bench, the petitioner, who stands on an identical footing, is entitled to the same order that is passed by the coordinate bench. ಅಲ್ಲಿ ಲಿಬರ್ಟಿ ಕೊಟ್ಟಿದಾರಲ್ಲ?
Liberty court, yes.
Yes. ಆಮೇಲೆ ಕಾಪಿ ಪೇಸ್ಟ್ ದಿ ಆರ್ಡರ್. ಈ ಪೇಜ್ 165 ಅಲ್ಲಿ ಮೇಡಮ್ 160 ಫಸ್ಟ್ 165 ವರೆಗೂ ಕೋಟ್ ಮಾಡಿ ಫಸ್ಟ್ ಹೇಳಿದ್ದು, ಆಮೇಲೆ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಪ್ಯಾರಾ 30 ಕೋಟ್ ಮಾಡಿ. ದಟ್ ಇಸ್ 165 to 168 167 ಫಸ್ಟೇ 167 ಮಾಡಬೇಡಿ, ಬರೀ 165. ಇಲ್ಲಿ ಫಸ್ಟ್ 161 ಇಂದ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ, ಫಸ್ಟ್ ಅದು ಅಪ್ ಟು 165, ಆಮೇಲೆ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಸೇಮ್ ಆರ್ಡರ್ 165 to 167 ಸಪರೇಟ್ ಮಾಡಿ ಅಂತ ಅಷ್ಟೇ, ಒಂದೇ ಸರಿ ಮಾಡಬೇಡಿ. ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಅವಾಗ, ಅದಕ್ಕೆ ಬೇಡ.
Lordship, writ petition number 26549, same matter. Lordship already passed the order.
I have already passed it.
Please, my lords.
Which is that?
24549.
I have released it now. Yes, yes. ಅಲ್ಲಿ ಹರ್ಡ್ ಸೌಂಡ್ಸ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಮಾಡಿ. Yes.
150.
Appearing for the petitioner.
Expert
Illa, my lord.
Ilva?
This is with respect to refund, not on receipt of refund. However, on filing of application, I have made 2 applications which are at
it will notice ಆಗಿದೆಯಾ?
advance copies have already been served, my lord, but they will
Served,
take
notice ಮಾಡಿಲ್ಲ?
Yes, my lord, but a similar matter is already filed. It's listed on 4th.
ಮಧು ಯಾರಿಗೆ? Learned counsel Arvind Chavan accepts notice for respondents 1 MN Kumar, ಆಮೇಲೆ 2, 3, 4 Arvind Chavan, 5 and 6 Madhu and Rao. Identical petitions here.
Fourth, my lord. I will give the number.
What they're asking is ದುಡ್ಡು ಕಟ್ಟಿದೀವಿ ಅಂತ refund application ಬೇಕು ನಾವು acknowledgement. ನಾವ್ ಹೇಳ್ತಾ ಇರೋದು ನೀವು ಫಸ್ಟ್ refund ಅಂತ coming to the aspect of refund, there is a deficiencies to be satisfied.
My lord, they
All
could
right,
not
if
have
it is
even
not
collected
covered,
that.
we'll hear you and pass
It's a
out.
covered matter, my lord. I have the division bench order and they could not have first of all collected. There's a clear instruction given by their very same department during investigation that they could not have taken any money.
Let them
However,
justify the action.
Fourth, my lord, fourth, a similar matter is listed. I can.
No, if there is deficiency in their application or deficiency in passing the order, we'll see. ನೀವು 2 ಲೈನ್ ಅಲ್ಲಿ ಮುಗಿಸ್ಬಿಟ್ಟಿದ್ರೆ
Order, ಅವ್ರು collect ಮಾಡೋಂಗೆ ಇಲ್ಲ ಅಂತ ನನ್ನ ಸ್ಟ್ಯಾಂಡ್, my lord. But fourth, my lord, similar matter is listed. It can be disposed of on the
ಫೋರ್ತ್
same.
ಆಗ್ಬೋದಲ್ಲ ಮತ್ತೆ? Yes, list on fourth.
Much obliged.
151.
My lord, serial number 151, I appear for the petitioner.
Petitioner,
My lord, serial number 151, I appear for the petitioner online.
why are you on VC?
My lord, I have conflicting Dharwad matters as well to attend to, my lord.
Multiple courts?
Please, my lord, I apologize, my lord. This is a simple GST matter. The government advocate has already been served.
GST matters are simple. Yes.
Please, my lord, this is an ex parte
Ex parte order,
adjudication
madam.
order.
Ex parte
My lord,
order.
the issue here is that the petitioner's authorized representative, who is a chartered accountant, did not appear at any stage of the proceedings, my lord, nor has he filed any replies.
We're passing the buck on the CA.
My lord, he is not informed the petitioner until recovery proceedings have been initiated, my lord. My lord, my prayer is very simple. My lord, I only ask for
Like-
this court to restore the
Your prayer
proceedings.
is very simple, like the GST cases.
Please, my lord, it's only to restore the proceedings to the stage of show cause notice, so the petitioner can adequately represent himself. My lord, he has an excellent case on merits. My lord, if his books are reconciled, the demand will go away entirely.
Then list on Monday.
Grateful, my lord.
Excellent case on merits ಅಂತ ವಾಪಸ್ ಹೋಗೋದು ಬೇಡ ಅಂತ. That's what she's telling. Yes, list on Monday. Yes,
Grateful, my lord.
yes.
152.
Second round, same identical amount confirmed, Your Lordship, without considering the direction to the Honorable Court on limitation as well as on merits.
Hmm.
Third party data, in my
Identical matter in the morning, madam.
Page, which is serial number?
serial number 110. 110. Your Lordship. It is listed on 11th. Your Lordship.
Tag this petition along with 110, list them both on 11th?
11th. please.
11th, yes. Learned Counsel Akash is directed to accept notice for the respondents, registered to print the name of so-and-so as appearing for the respondent, list on 11th, yes.
153, 154 dispose, 155.
That's 153 and 154 are different matters, please. Not ITC block.
ನೀವೇ ಹೇಳಿದ್ ಮತ್ತೆ ಸೇಮ್ ಅಂತ
161 to 165. ಅದು ITC.
ಏನಿಲ್ಲ ನೀವೇ ಹೇಳಿದ್ದು ಇದನ್ನು ಎಕ್ಸೆಪ್ಟ್ 155 ಅಲ್ಲ ಯಾವುದು ಸೀರಿಯಲ್ ಅಲ್ಲಿ
140, 143, 161 to 166. Other than 165 is ITC block.
ಇದೇನು 153
153.
ಅದು ಬೆಳಗ್ಗೆ ಜೇವಾಗಿ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್ ಮತ್ತೆ ಡಿಸ್ಪೋಸ್ 153 154 ಬೇರೆನೇ ಎರಡು
Please.
ಇದೇನು
Idರಲ್ಲಿ, my lords, order came to be passed under section 73. We filed a rectification application. They, my lords, gave a notice for personal hearing at page 52, saying that these are the documents according to the annexures have to be brought. They didn't mention the annexures and they have disposed of the rectification application.
Copy ಕೊಡಿ. Learned counsel for the petitioner to serve set of papers upon the learned HCGP. First HCGP accepts notice for the respondent. Petitioner to serve set of papers upon the HCGP. Fourth ತಗೊಳ್ಳ? First.
My lords, may I have it on fourth, please.
Why?
First, I have some difficulty.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಇದೆಯಾ?
ಇಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಮ್ಯಾಟರ್ ಇದೆಯಾ?
Sorry.
ಹಾಗಾದ್ರೆ ಅವತ್ತೇ ತಗೊಳ್ಳೋದು. ಎಸ್. ಫಸ್ಟ್ 153 154 ಹೋದೇನಾ?
Please.
Same 153 154 first.
Lordship, for 155, I'm appearing, Your Lordship, for
55.
Scrutiny assessment. Learned
Yes,
counsel
sir.
M. Tirumalesh is directed
I'm
to accept
challenging
notice for the
148.
respondent.
No,
List
stay
the
may be
matter.
granted, Your Lordship.
Why are you on VC?
Lordship, I have some injury on leg, Your Lordship. My leg got twisted.
That's okay.
My sincere apology for that.
ಇಲ್ಲ ಅಲ್ಲಿ ಕೂತ್ಕೊಂಡು 4-5 ಕೋರ್ಟಲ್ಲಿ ಅಪೇರ್ ಆಗ್ತೀನಿ
ಇಲ್ಲ,
ಅಂದ್ರೆ
ಇಲ್ಲ, sir.
ಎಸ್ Yes, sir. Learned counsel M. Tirumalesh is directed to accept notice for the respondent. Petitioner to serve set of papers upon the aforesaid counsel. The learned counsel for the petitioner submits that the notice, the proceedings taken up under 148A is without jurisdiction. A
Yes.
perusal at the documents would indicate it is so, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings till the next date of hearing. List the matter on 18th September.
Annexure D and further proceeding, Your Lordship.
Interim order as spread for. Yes.
Much obliged, Your Lordship.
Next.
156.
ITO. Dilip, ಇದು ಅಷ್ಟೇ 148 beyond limitation. The learned counsel appearing for the petition, the petitioner shall serve on the counsel M. Dilip, who is directed to accept notice for the respondents. The petitioner is before this. ನೋಡ್ಬೇಕಾ? ನೋಡ್ಬಿಡಿ ಆಮೇಲೆ ತಗೊಂತೀನಿ. ಅವ್ರಿಲ್ಲ ಹೆಂಗು ಅವರು ಕೊಡಿ ಮಾಡಿ. Give the petition. Yes, pass over. Sandeep.
157.
I'm sorry, Marge, I'm unwell. That's why I'm online. I'm sorry, Marge.
Unwell.
I am unwell. I wanted to submit
Unwell
that.
is okay. The learned counsel appearing for the petitioner submits that the notice so issued to the petitioner was issued to the secondary mail address which stands covered in favor of the SSE as in terms of a judgment appended to the petition. The learned counsel, in the light of the said submission, Dilipa,
Please,
counsel,
for the response.
light of the said submission, there shall be an interim order as spread for till the next date of hearing. List the badwa. ಅದಕ್ಕೆ you read and come back. Interim order ಬೇಡವಾ?
Till then,
ಆಯ್ತು, list the matter on 4th. But demand ಇದೆ.
till
Don't
then I
act.
may be highly protected.
The respondents are restrained from acting on the demand till the next date. Yes.
Achha.
List the matter on 4th ಹೇಳಿದ್ನಲ್ಲ, 4th in preliminary hearing.
Please.
158.
Faceless issue is involved in this.
Pass over.
Right. Great.
ಆಯ್ತು, ನೋಡೋಣ. ಸುಶಾಲ್ ತಿವಾರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಡಿ ಈಗಲೇ.
Copy, sir.
Go out and get a photocopy and give him.
I'll serve it now.
Yes.
59.
My lords, in 159 also appear for the petitioner. My lords, the petitioner is actually a practicing advocate. What has happened is, my lords, there were cash deposits made in the Nyayamitra bank account amounting to 15 lakhs. Now, under the Act and rules, my lords, the bank is required to report if more than 10 lakhs is deposited in a year. They have erroneously reported it 4 times.
Advocate unexplained money.
Yes, they have reported the transaction 5 times. So that is why it has crossed a particular limit, and the assessment was also done ex parte.
Huh? Why you have not filed reply to the notice?
Again, the notice was sent only the erstwhile chartered account to my lords, although my primary email ID is my own. It was not sent to me.
Secondary mail address is understandable. Erstwhile chartered account, all of you are passing the buck on the CA.
No, and even apart from that, my lords, there is a prima facie error on the part of the bank, and the bank is also.
ಅವ್ರದೇ ಜವಾಬ್ದಾರಿ. What is that email ID, sir? Primary, secondary, tertiary?
No, it's the secondary. But more than that, may I just take my lords, so the other aspect of the matter is that the bank has admitted its error. There was a cash deposit of only 15 lakhs. They have reported as 90 lakhs. And only on that ground, the addition has been made.
Page.
The bank statement, my lords, will find at page 88, annexure F.
Page 88.
Please, my lords. My lords have that.
Where is the admission of error by the bank?
Admission, my lords, will kindly see page 153, annexure W1, 153.
153. ಅದು ಮಾಡ್ತೀರಾ ಸರ್ ನೀವು?
The time limit to file so has already lapsed, my lords. That's what is happening.
Beyond limitation ಅಂತ ಡಿಸ್ಮಿಸ್ ಮಾಡಿ ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಬರುತ್ತೆ. ಅದು ನೀವೇ ಮಾಡ್ಬಿಟ್ಟಿದ್ರಿ, ಇಲ್ಲಿ ಯಾಕೆ?
My lords have page 153, my lords.
ನ್ಯಾಯಮಿತ್ರ ಸಹಕಾರಿ ಬ್ಯಾಂಕ್.
The High Court branch itself, my lords. Just the second line, I kindly see.
15 lakhs ನ 5 ಸರಿ ಕ್ಲಿಕ್ ಮಾಡಿದಾರಾ?
And they reported it as 89 lakhs. And they have admitted that, and they have.
You should have withdrawn 80 lakhs from that. ಒಂದು ಚೆಕ್ ಕೊಡ್ಬೇಕಾಗಿತ್ತು, ಸೆಲ್ಫ್ ಚೆಕ್. ಈ ತರ ತೋರಿಸ್ತಾ ಇದೆ 80 lakhs ಕೊಡಿ ಅಂತ.
In fact, the error also, what happens when the bank reports it to the department, I am not made aware of
that error, sir.
I'm sorry, ma'am.
Yes. Learned Counsel and Dilip is directed to accept notice for the respondent.
1 to 4 and 6, 7 minutes. 5 is the bank minutes.
5 is the bank. Which bank? Again, bada bidi. Formal party.
Please.
Yes. 1, 2, 3, 4,
6, 7.
6 and 7. M. Dilip. List on 11th.
Till then, maybe there's a recovery notice issue. On 2nd of August, there's a recovery threat which has been annexure V. Malaj, may kindly see.
Don't precipitate, sir. ಇಲ್ಲ ಸ್ಟೇ ಮಾಡ್ತೀನಿ. The list on 4th then.
Till then, because there is a threat of recovery.
What threat, sir?
That pursuant to the recovery letter, my lords, at annexure V, there is an active threat of attachment.
Nothing will happen in case
his undertaking may kindly be recorded, my lords. I'm only
anyway, this bank al tane ನೀವು recover ಮಾಡೋದು account na.
There are other accounts also, my lords. My only concern is that.
List on 4th. The income tax is a little touchy about interim orders.
My lords, my learned friends, undertaking may kindly be recorded, my lord. Till then, I'm not asking for.
ಏನು undertaking ಕೊಟ್ರೆ? He has not undertaken anything.
It's a humble request, my lord. There is a blatant error on the part of the bank. It's an ex parte order, and the notice is issued by a jurisdictional AO. The notice also is issued by a jurisdictional AO. So on that ground itself, the order may have to go.
All right. 4th. Appeal is pending.
I've also sought alternate prayer that till the
Then you
appeals are
pursue the appeal, will protect you till the appellate authority
Yes,
decides.
I've urged those prayers also, my lords. My lords, may I kindly see the prayers at page 35. Page 37, my lords, of the petition. My lords have that, my lords.
Which prayer?
Prayer 16 and 17, my lords.
I'm not asking page.
Yes, yes, sub prayer, because there's
Prayer
page 30
16, 17.
Yes, my lords, because the
Page
department
number
issues,
prayer ಆಗಿತ್ತಾ?
there are assessment orders, penalty orders, and each of them separate computation sheet demand
Which
notices.
is the prayer that disposal of the appeal?
16 and 17, my lords. 16 is for disposal
Please
expeditiously.
grant this prayer. Huh?
And
Since the appeal is pending,
please,
don't take any coercive steps till the appeal is decided. Amele
Please.
you can.
yes.
All right. Yes. The petitioner is before this court seeking plethora of prayers, but would restrict his submission for the present to the prayer number
16 and
17.
17. 16
Prayer
and
number
17.
17. Huh?
16 and 17, my lords.
16 and 17. 16 and 17. The learned counsel appearing for the petitioner submits on the same grievance, the petition challenging the same grievance and challenging the orders impugned in the subject petition. The petitioner has preferred an appeal before the fourth respondent. The said appeal is pending adjudication before the authority. In the interregnum, the demands are sought to be recovered in terms of the impugned assessment orders, which are all at large before the appellate authority. In the light of the issue pending before the appellate authority, till the appellate authority, i.e. the fourth respondent, decides the appeals on its merit, the demand of recovery, no coercive steps with regard to demand of recovery be made against the petitioner, the assessee. It is open to the appellate authority to regulate its procedure and proceed with the consequent action only after answering the appeal on its merit after affording hearing idya?
Please, my lords.
In accordance with law and in consonance with principles of natural justice. In that light, the petition stands disposed. Other will dispose it on the aforesaid ground. With the aforesaid observation, the petition stands disposed, leaving open all the contentions of both the parties to be urged if need arises after the order of the appellate authority.
Much obliged.
Next.
160.
Ordered accordingly.
Here for the petitioner, Lords, there's a demand order passed, Lords, without show cause notice, without Lords hearing me. Based on that, Lords, my refund order, that my request, Lords, for refund of Lords, my pre-deposit, since I succeeded in before the SESTAT, that also, Lords, is refused. Both Lords are challenged before my Lords.
Here ಮಾಡಲ್ವ ಯಾರನ್ನು ಅಥವಾ ಯಾರು ಬರೋದೇ ಇಲ್ವಾ ನಿಮ್ಮ ಮುಂದೆ? Yes, Jeevan. Huh? The learned counsel Arvind Chavan is directed to accept notice for the respondents. The learned counsel Vivek Holla appearing for the petitioner. Idan show cause 2013 da.
Lords, there's one proceeding that culminated in the
The
SESTAT order.
learned counsel appearing for the petitioner Vivek Holla would submit that a demand order
Demand order.
Demand order is issued against the petitioner without issuing any show cause notice towards the said demand, and therefore is in violation of law and in principles of natural justice, is what the learned counsel would contend. Therefore, till the learned counsel Shri Arvind Chavan would secure instructions and make submissions, the demand shall not be acted upon. List on 18th. Yes.
One 161 to 164 disposed. 165.
May it please your lordships. My lords, this is a matter where the jurisdiction to tax is under question. products manufactured at a central kitchen, what rate it would attract. The issue was whether it is services or is it goods.
Are you talking of cloud kitchen?
Cloud kitchens and centralized kitchens, what would be the rate that it would attract? Do you call it services or do you call it goods? There's a brief history, my lords. 1 minute I will summarize.
Yes.
In Northern India caterers, my lords, is prior to the 46th Amendment. The Supreme Court had held that essentially services in a restaurant are services, they're not sale of goods. But to get over that, the 46th Amendment was made, where they inserted 366(29)(a), and several clauses were inserted. One such clause was to deem sale of goods in a restaurant services also. Now, subsequently, my lords would also find that in the service tax regime, they brought about the service portions to tax in this. This continued till the GST regime. And the GST regime came, my lords, they knew that this had to go one way or the other. So specifically, my lords will see, I'll just place a short compilation for your lordship's benefit.
Yes.
The lordships would look at schedule page 5, my lord, schedule 2.
Yes.
6, entry 6, my lords. Composite supply. The following composite supply shall be treated as a supply of services, namely, the second clause, my lords, B, supply by way of or part of any service in any manner whatsoever of goods, being food or any other article for human consumption or etc. etc. So what they're trying to do, my lords, is to narrow down the disputes and tax everything as services. Now, after having done that, my lords, they also issued a circular saying cloud kitchens and centralized kitchen will come under this service tax net will be taxed at 5%. So that 5% has been discharged. Howsoever, the show cause notice, my lords, a series of notices have been issued where they want to tax it as goods and not services again. Now, that is the issue before your
What
lordship.
would be the variation?
13%, my lords. Similar issue was considered by this court in 11/567 of 2023, where, my lords, this is at annexure L, page 472, my lords. Similar matters are under consideration and interim orders have been granted. Essentially, lordships will have to lay down the law whether this should be taxed as services
or goods.
Yes.
Heard the learned senior counsel Raghuraman appearing for the petitioner. The learned senior counsel, the petitioner is a cloud kitchen or a centralized kitchen. The learned senior counsel would submit that hitherto the cloud kitchen or the services in a restaurant were not taxed. Certain amendments come about to the act, bringing in services in the restaurant also under the ambit of service, under the ambit of service and as tax consequently. The petitioners submit that the cloud kitchen, the learned senior counsel further submits that the cloud kitchen and the centralized kitchen were also depicted to be under the quote-unquote service and tax was imposed. The tax has been paid by these petitioners. The respondent has later done a volte-face by bringing in the cloud kitchens under the ambit of tax for the as goods and not services. In that light, the goods and services. The learned senior counsel takes relies on identical interim orders granted by the coordinate benches. Which page is that? 470?
470.
471.
71, 472.
Tag this petition along with 471, 472.
Lordships could keep it at a particular day.
I'll keep it, yes. There shall be an interim order as prayed for in the light of the aforesaid issue and the interim order subsisting in the companion petitions. List these matters on learned HCGP is directed to accept notice for the respondents list these matters on, we'll take it on a particular, on 12th September.
My lord.
Yeah, 12th, but 12th at the Competition Commission. 11th September.
My lords. 2:30 man.
11th September at 3:30.
3.
Yes.
Deeply obliged.
Be ready. Why? Prepare a 12 days. ಆಯ್ತು 18th ತಗೋಣ ತೊಂದ್ರೆ. And 18th September at 3:30 PM. Same. ಅವತ್ ಮತ್ತೆ ಟೈಮ್ ಕೇಳಬೇಡಿ ಸುಮ್ಮನೆ. Yes.
Deeply obliged.
Yes.
I will prepare a synopsis and.
Yes, ಅದಾದ್ರೆ it will be helpful for me also.
Yes. Should I file it in advance?
In advance ಕೊಟ್ರೆ I'll go through it and.
I'll do that. Deeply obliged.
Yes. ಅದೇ ಇದು 166 ಆಯ್ತಲ್ಲ. ಫೇಸ್ಲಿ ಇದು
ಸೀರಿಯಲ್ ನಂಬರ್ 257
ಏನದು?
ರಿಮೈಂಡ್ ಮಾಡಬೇಕಾಯ್ತು.
ರಿಮೈಂಡ್ ಮಾಡಕ್ಕೆ ಡಿಮಾಂಡಾ?
No demand, my lords.
Wait.
Like,
Wait, yes. Faceless ತಗೊಳ್ಳಿ. Orders ಅಲ್ಲಿ withdrawal ಇದೆಯಾ? Just one moment. Orders ಕರೆದ್ಬಿಟ್ಟು I'll get back. Memo for 202.
202.
In terms of the memo, withdrawn, disposed as withdrawn.
203.
my lord.
ಇದು ಯಾವ್ದು ಬೆಳಗ್ಗೆ 203 ಜೊತೆಗೆ ತಗೋಬೇಕು ಅಂದ್ರಲ್ಲ?
ಅದೊಂದು ಮೂಡೆ 230 ಹೌದು.
ಇವಾಗ ಮೂಡೆ ಮೆಮೋ ಅದ್ ಬರ್ಲಿ, ಅದ್ರ
Please,
ಜೊತೆ ತಗೊಂಡು.
please.
Yes.
204.
2 weeks time is granted to do the needful.
205.
A week's time is granted to do the needful.
206.
In terms of the memo.
207.
ಇದು letter of extension extended by 3 months. ಆಮೇಲೆ ಬರೀತೀನಿ ಮೇಡಮ್, ಚೇಂಬರ್ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ. In terms of memo.
209.
In terms of memo. ಏನಂತ ಆಗಿದೆ? ಸೂಟೆ ಆಗಿದೆ ಅಂತ. ಸೂಟೆ ಕ್ಲೋಸ್ ಆಗಿದೆ ಅಂತಲ್ಲ. The learned counsel for the petitioner submit 209 ಅಲ್ಲಿ ಮೇಡಮ್. Learned counsel for the petitioner submits that the petition is rendered infructuous in the light of the suit itself getting closed. ಇದು ಯಾವ್ದ್ರಲ್ಲಿ ಬರ್ತಾ ಇದೆ ಅದು? ಎಸ್. In the light of the said submission, this is disposed as having become infructuous. 210 ಅಷ್ಟೇನೆ. Same, yes. Same order in 210. 211 report of notice. ಏನಿದೆ ಮೇಡಮ್?
Notice is served, your lordship. We had been directed to serve the notice to the respondent through the trial court. That is being carried out.
Learned counsel ಇದಾರಲ್ಲ? Correct.
They have to come on record, your lordship.
Oh, seriously? Yes, madam. Learned counsel appearing for the respondent, learned counsel so and so undertakes to enter appearance for the respondent, registry to print the name of so and so is appearing for the respondent. List of the counsel would seek 2 weeks time to file statement of objections. List after 2 weeks, interim order subsisting will continue to the next date of hearing. Next.
212.
May I request for a date, your lordship?
No, madam. Yes. 212 in terms of the memo withdrawn. 213 same order, 14 same order.
215.
15. In a week's time is granted to do the needful. Interim order subsisting will continue to the next date of hearing.
216.
A week's time is granted to do the needful.
217.
Same order. Interim order ಇದ್ರೆ continue ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್. ನೋಡಿ.
Memo for dispensation of notices. 1 to 4.
1 to 4. The learned counsel for the petitioner has filed a memo seeking dispensation of issuance of notice to respondents 1 to 4. In the light of the memo, the notice to 1 to 4 stands dispensed at the risk of the petitioner. Post immediately after service of notice upon respondents 2 to 12, interim order subsisting will continue to the next date of hearing.
219.
Same order.
20.
A week's time is granted to do the needful.
221.
Same order.
I have served, my lord, the counsel appearing on behalf of the respondents 1 and 2.
You are there, madam? learned huh?
3
Kamegowda ಅಂತಿದೆ.
3 to 4. Not 3 to 46, I had sought for dispensation. Your lordships had granted.
Already dispensed.
Please, my lord.
Ah.
1 and 2, my lord, I have served the learned counsel appearing in the trial court.
Ah.
I have filed the acknowledgement on 30th itself. Your lordship's order is dated 29th.
But 11 and 12 ಯಾರು?
ಇವರು ವಾಲಂಟರಿ ಆಗಿ ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ.
ಮತ್ತೆ ನೀವು ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಕೇಳಿದ್ದೀರಾ, ಅವರು ಕಂಟೆಸ್ಟಿಂಗ್ ರೆಸ್ಪಾಂಡೆಂಟ್
ಇಲ್ಲ ಇಲ್ಲ.
ನೋನಾ ಪರವಾಗಿಲ್ಲ, ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಬಿಡಿ, ಯಾಕೆ ತೊಂದರೆ ಕೊಡ್ತೀರಿ?
Very well.
Yes. The learned counsel submits needful has been done, office to verify.
Interim orders.
Of list after 2 weeks, interim order subsisting will continue to the next date of hearing.
Connected matter, your lordships have posted it on 3rd, my lord.
ಬೇಡ ಬರ್ಲಿ. Yes.
Please. Good.
22.
A week's time is granted to do the needful.
23.
Petitioner, sir, the copies to trial court.
Learned counsel submits needful has been done, office to verify.
Interim order.
Interim order subsisting will continue to the next date of hearing.
24.
Post immediately after service of notice upon the respondent, interim order if any, ಅದು ನೋಡ್ಕೊಂಬಿಡಿ ಮೇಡಮ್. Yes.
225. Same.
225 same, post immediately. 226 same.
For petitioner, my lord.
227.
For petitioner, my lord.
227.
226 and 227.
Both.
Proceeds been paid, my lord. Interim order to be extended, my lord.
Yes, madam. Learned counsel submits needful as, no, sorry, post immediately after service of notice upon the unserved respondents, interim order if any shall continue till the next date of hearing.
28.
Learned counsel Akash B. Shetty seeks 2 weeks time to file statement of objections. Objections, if any, by the 18th, list on 18th.
229.
Office objections.
It's complied, my lords.
Learned counsel submits office objections have been complied with, office to verify. First time ಬರ್ತಾ ಇರೋದಾ?
ಇಲ್ಲ madam, ಇಲ್ಲ.
Interim order ಇದೆಯಾ?
Interim order. I
List
paid
on
10% additional tax
oh,
also.
the list after 2 weeks, interim order subsisting will continue.
My prayer is for setting aside of the orders, my lords.
Lord,
A date may be fixed.
24th September. Yes. 25th September. ಕೊನೆವರೆಗೂ ನಿಮ್ಗೆ ತೊಂದರೆ ಕೊಡೋದು ಬಿಡಲ್ಲ ನಾವು. Yes.
230.
Post immediately after service of notice upon respondent, list after 2 weeks. Hindustan Tools. Yes. ಏನು?
Sir, party in person.
ಅದು ಗೊತ್ತು.
He is unable to appear personally because of ill health. He is
Who are you?
I am one of the partners of Hindustan.
You are a party to party in person?
Partner of Hindustan.
Partner of party in person.
Partner of party.
What do you want now?
Next week.
Next week. The partner of the party in person seeks a week's time on the score that the party in person is indisposed. List the matter. 11th?
4th.
4th. 4th. Yes.
232.
Non-filing of copies served so and so. Remand. ಇವರು ಈ ಕಡೆ ಇದ್ದಾರೆ.
ನಾನು ಈ ಕಡೆ. My lord, this is a case
ಹಾಗಾದ್ರೆ ರಿಮಾಂಡ್ ಮಾಡಂಗಿಲ್ಲ.
This is a case where, my lord, then your lordship may kindly quash it.
Dismiss.
This is a case where, my lord, ex-servicemen's retirement benefits have been, my lord,
attached.
Added as, my lord, unexplained, my lord, money. Yes.
Retirement benefits
unexplained ಅಂತ ಮಾಡಿದ್ದಾರೆ. Ex parte order, he was settled in Kerala, my lord. I think, my lord, they have sent a notices to the Bangalore. After retirement, he settled in Kerala. Notwithstanding.
Man is in Bangalore.
Pan, my lord.
Pan is in Bangalore. Man is in Kerala. Right. We'll send it back.
Please.
To whom?
This is, my lord, assessment unit.
Only assessment officer. Assessing officer.
Assessing officer.
Right. Allowed cost back.
All bank accounts are to be defreezed, my lord.
As a consequence, that will happen. Defrozen. Yes. Petition is allowed. Impugned order so and so stands quashed. As a consequence thereof, the matter is remitted back to the hands of the respondent to hear the petitioner and pass necessary orders. In the light of the quashment of the orders impugned, As a consequence thereof, the attachment of bank account of the petitioner in which his pension is deposited shall stand defrozen forthwith. Yes.
Orders at 2:30 PM.
Faceless. CRP will take it later.
Lordship, may I mention, Your Lordship? Preliminary B group matters, Your Lordship.
B group, wait, madam, we'll see.
Lordship, 252,
Wait,
if
I'll,
it's not
I'll
possible.
call it at 5 o'clock.
My lord, one subject.
Yes.
No, if it is not
Who-
possible
who-
today,
no,
Your Lordship,
faceless, wherever faceless is there, I'm taking all those.
can it be
203,
next
my
week, Your Lordship? 252.
203 ಯಾರು ಇರ್ಲಿಲ್ವಲ್ಲ ಇಲ್ಲಿ.
Interim order may explain.
wait, ಅದು ಇನ್ನೊಂದ್ರ ಜೊತೆ ಕರೆದಿದ್ದಾರೆ. 230 ಯಾರೋ ಮೂವ್ ಮಾಡಿದ್ರು 203 ಜೊತೆಗೆ ಅಂತ. Some elections are being held ಅಂತ.
Lordship, serial number 252. Can
ಬರ್ಲಿ
it
ಅದ್ರ
be
ಜೊತೆ
next
ತಗೊಂಡು.
week?
Serial number 169, my lords. Kindly out on Monday, my lords. Trial court.
ಯಾವುದು ಮೆನ್ಷನ್ ಮಾಡಬೇಡಿ, ಆಮೇಲೆ ನಾನು ತಗೊಂತೀನಿ. Yes, CRP I will definitely take. All CRPs I will take at 5 o'clock after I finish faceless. Yes, who is going to start? Faceless ಯಾವುದು?
It's like given a.
ಅವತ್ತಾಯ್ತು ಎಲ್ಲ. Yes, sir.
I have to come back, madam.
I will hear the battery this side.
Yes, madam.
Chaitanya sir has not submitted.
Maybe my lords could hear me after the other side would, or I can submit.
ನೀವು submit ಮಾಡ್ಬಿಡಿ.
I shouldn't be repeating what Mr. Shankar has already argued.
That's all.
Otherwise, I can very briefly submit.
Anything is tuition to me, no problem, you can. In which matter are you appearing, sir?
My lords, I am in serial number 287, 288. My lords, 327 have to be delinked, my lords. It wouldn't have.
ಆಯ್ತು, that dealings ಎಲ್ಲ ಆಮೇಲೆ will do. Yes.
327.1.
ಅಲ್ಲ, ನೀವು appear ಆಗ್ತೀರಿ 287, 288.
327.
You take any which petition is convenient to you?
My lords, any petition, but the issue remains the same.
That is why one you take, ಆಮೇಲೆ I'll hear you.
Issue the same. I'll explain.
Yes.
Yes.
It is not writ petition specific, only for me to gather the papers ಅಷ್ಟೇ.
Yeah. My lords, 288 may be taken.
288 ಕೊಡಿ.
288 may be taken.
Yes, sir. You have Dilip and ಯಾರ್ಯಾರು ಇದ್ದೀರಾ all on this side. You have seen the orders passed by two different high courts, division benches of two different high courts, particularly Madras, which is followed by Delhi again, saying it will revive. It is a balance for both the rights, no problem at all. All right.
There are other judgments also, my lords, where it says, my lords, I left just update from last week, my lords. What had happened, my lords? They said 2 SLPs were dismissed. My lords, on the Friday, my lords.
Review ಹಾಕಿದ್ದೀರಾ?
Not that, my lords. Assessees, my lords, there was one SLP posted before Justice Nagaratna, my lords. Their assessees was represented. My lords, they said 2 SLPs were already dismissed. My lords, Honorable Supreme Court has issued notice even after that, my lords.
It's all right.
My lords, that even after the assessee represented, my lords, they said 2 SLPs are dismissed.
No, there is no stay of any order.
There is no, my lords, why? I'm just bringing it to your lordship's notice, my lords. Notice was issued even after dismissal of SLP.
Senior counsel Shankar has clearly said, when taken through all the orders, those division benches are clear. I will definitely pass that order. Why keep these petitions pending?
There is one
Only to get the numbers of pendency, nothing else.
I'm just bringing it to your lordship's notice. My lords, one Bombay High Court decision, my lords.
Aito, let Chaitanya sir finish it. Yes. Yes, sir.
May it please, my lords. My lords, these are the petitions, my lords, where the notices and the proceedings for choosing, my lords, the case for the purpose of assessment in the new regime, my lords, which my lords would know that the new regime effective from 1st of April 2021.
Yes.
Where my lords, first under 148A within bracket small b will have to be issued. Then a hearing would take place. Then my lords, the assessing officer will have to pass an order calling it as a fit case for the purpose of issue of notice, which order will have to be passed with the prior approval. And my lords, as soon as the said order is passed, which is an order under 148A within bracket small d, my lords, a notice under 148 would then be issued. Lords, what happened was, Lords, after 1/4/2021,
The new regime,
the
faceless regime.
Faceless, I'll come to, my Lords.
Yes.
Faceless is one aspect. This is the normal aspect of how a reassessment should be made. So department did error in as much as it did not follow the new regime. It went ahead and issued notices under the old regime, which, my Lords, most of the Honorable High Courts, including this Honorable High Courts, quashed this on the premise that you have not followed the new regime. Then, my Lords, the matter reached the Honorable Supreme Court. Honorable Supreme Court, in respect of those matters then existing, Lords, which came before the Supreme Court, stated that new regime has to be meticulously followed. And the Honorable Supreme Court concurred with the decisions of all the High Courts to state that if the old regime is followed, it is bad. And therefore, my Lords, what the Honorable Supreme Court did is to deem the wrongly issued notice under 148A within brackets B and asked the department to proceed. Thereafter, my Lords, the faceless regime started. The department in those cases also continued the error of proceeding manually on it. That apart, this batch before, my Lords, would also consist of those cases which were initiated on the new regime only, but not through the faceless regime. Therefore, my Lords, these petitions are before, my Lords. Now, my Lords, the provisions in the Income Tax Act, my Lords, in respect of various proceedings were intended to be done in a faceless manner with three avowed purposes in mind. That's one is to remove the interaction between the assessee and the department. This would enhance the transparency. Two, my Lords, dynamic jurisdiction. My Lords, they wanted to get rid of the conventional method of the jurisdictional assessing officer, which would then mean, my Lords, there wouldn't be proper optimal utilization of resources within the department. So dynamic jurisdiction where, my Lords, I could be assessed by somebody in Tripura. So this was what this was brought in. Then at the same time, they also introduced the faceless assessment schemes and the procedures. What they did in this regard, my Lords, most importantly, three important provisions will have to be taken note of, my Lords. One is section 130 of the Income Tax Act. Through 130 of the Income Tax Act, my Lords, they have brought in they have enabled the central government to issue a scheme for faceless conferment of jurisdiction. Otherwise, my Lords, the jurisdiction would be conferred by the order of the Central Board of Direct Taxes, delegating its lower authorities to in turn delegate, my Lords, the powers of the assessment. All these orders are essentially passed under section 120, read with section 124 of the Income Tax Act. And, my Lords, section 130 was enacted to enable the board to bring out a scheme to seamlessly confer the jurisdiction. I'll explain why this is done, my Lords. And accordingly, a scheme has been brought in to confer faceless jurisdiction. Along with that, my Lords, they have brought in 144B with effect from 1st of April of 2021, where they have codified the whole scheme of faceless assessment, not as scheme, but as part of the statute. Unlike in 130, my Lords, where a scheme has to be brought out by the Central Board of Direct Taxes, under 144B, they have enacted the faceless procedure itself. Thereafter, my Lords, they also brought in 151 capital A, which provision, like 130, enabled the Central Board of Direct Taxes to issue a faceless scheme for the purpose of, my Lords, carrying out the exercise of issue of notice under 148. So I may clarify one thing, my Lords, here. That 151A scheme provided for stage up to the issue of notice under 148. And thereafter, the assessment in a faceless manner will have to be done under 144B. The whole, if, my Lords, were to look at all this in an integrated manner, how it works, my Lords, is the cases for reassessment would be picked largely on the basis of risk management strategy, which, my Lords, is a strategy adopted by the Income Tax Department, applying artificial intelligence and the machine learning, where, my Lords, they will have the set risk parameters. On the basis of those set risk parameters, the cases will get flagged. And as they are flagged, my Lords, they are to be picked for the purpose of reassessment. And as soon as the cases get flagged in the RMS, which is without the human intervention, then, my Lords, the system is so integrated, so much so that the jurisdiction under 130, my Lords, would get conferred to
by way of an automated allocation algorithm
To
to somebody,
anybody.
somebody who assessee wouldn't even have a chance to know. So it will get allotted to somebody. As soon as that gets allotted, my lords, section 151A will kick in for him to initiate
Proceedings.
the proceedings as to whether it's a fit case for issue of notice and
Reassessment.
reassessment. And once, my lords, so-called officer passes an order stating that it's a fit case for issue of notice under 148 and hence issues a notice under 148, my lords. Likewise, the section 130 would work in a manner where it will then go to a faceless officer for the purpose of assessment under 144B. So this is how, my lords, it's all integrated. This being the case, my lords, and this being mandatory, the question before, my lords, is department right in not following this faceless system? So with this brief
Now,
background,
one clarification,
my lords.
as I heard on the last occasion.
My lords.
Now, this, despite all this being in place, the notices are manually issued, proceedings are manually taken, and orders are passed.
Exactly.
That is in violation of
Mandatory.
mandate, which Supreme Court says you have to follow.
Exactly. Yes. Now, my lords, with this background, I would take, my lords, to section 151A.
Yes.
And before that, my lords, 130 maybe just kindly seen, my lords, that would make it complete. These three sections are very critical.
Page?
My lords, may kindly take
I'm
section
holding
130.
I'm holding writ petition 17352.
My lords, may kindly take the Income Tax Act.
150.
This section, my lords,
Ah,
at page 1.924.
1.924. Yes, sir.
My lords will find section 130 on the left-hand side.
Yes, I'm there.
Faithless jurisdiction of income tax authority.
Yes.
Now, my lords, this would provide for, without bothering my lords reading this, it will provide for bringing out a scheme to confer faithless jurisdiction. A scheme also has been brought in place, my lords, which at this point in time may not be really relevant. Now, my lords, may kindly go to 144B of the Income Tax Act.
144B.
Capital B, my lords.
Yes.
My lords will find in page 1.1004 on the left-hand side.
1.1004.
Yes, my lords, on the left-hand side.
Yes. 144B.
144 capital B.
Yes, I'm there.
Now, my lords, on the left-hand side,
Yes.
faithless assessment. Notwithstanding anything to the contrary contained in any other provision of this act, the assessment, my lords, may also kindly notice reassessment. My lords have found that?
1 minute.
I'm sorry, my lords. Or my lords referring to 2025 Act?
120. Yes.
1.1004.
25, yes. 140 faceless assessment.
Yes, my lord. 144B. Subsection 1.
Yes.
What my lords are reading is effective 1/4/1922.
Yes.
Notwithstanding anything to the contrary contained in any other provision of this act, the assessment, my lords are there?
Yeah, I'm there.
Reassessment, recomputation. My lords may kindly see reassessment as well. Recomputation under 143(3), 144 and 147, which is reassessment section.
Yes.
As the case may be, with respect to cases referred to in subsection 2, shall be made in a phaseless manner as per the following procedure. Then, my lords, the whole lot of procedure will continue from page 1.1012 onwards. So, my lords, at this point in time, it may not be necessary, my lords, to take, except noting that, my lords, that the scheme is itself codified as in the form of section. Now, my lords, may most kindly go to the important section here, 151 capital A.
151A.
Capital A, my lords, which my lords will find in page 1.1040.
1040.
Yes, my lords.
Yes, I'm there.
Lords, on the left-hand side, fairless assessment of income escaping assessment.
Yes.
Subsection 1. The central government may make a scheme by notification in the official gazette for the purposes of assessment, reassessment, or recomputation under section 147 or issuance of notice under section 148 or conducting of inquiries or issuance of show cause notice or passing of order under section 148A or sanction for issue of notice under section 151 so as to impart a greater efficiency, transparency, and accountability by A, eliminating the interface between the income tax authority and the assessee or any other person to the extent technologically feasible. B, optimizing utilization of the resources through economies of scale and functional specialization. C, introducing a team-based assessment, reassessment, or recomputation, or issuance or sanction of notice with dynamic jurisdiction. Then, my lord, subsection 2 is also equally important. The central government may, for the purposes of giving effect to the scheme made under subsection 1, by notification in the official gazette, direct that any of the provisions of this act shall not apply or shall apply with such exceptions, modifications, and adaptations as may be specified in the notification. That is a cut-off date for issue of that. Now, my lords, subsection 3 is equally important. Every notification issued under subsection 1 and subsection 2 shall, as soon as may be, after the notification issued, be laid before each house of the parliament. Lord, this section empowers the Central Board of Direct Taxes not only to issue a scheme, but also, my lords, specify that other provisions of the act should not apply if the scheme were to come in. Obviously, to the extent of incompatibility and inconsistency.
So that is not the
And also, the notification so issued by the Central Board of Direct Taxes will have to be placed before both the houses of the parliament. Now, my lords, in exercise of powers under this particular section, notification has been issued, my lord. I may share this convenience compilation, my lords.
It's already there in the paper book. It's already in the paper book given by
Shankar sir.
At page.
It is here.
The scheme is at page 112, 212.
Let Chaitanya sir finish.
My lords.
Yes, sir.
My lords, this scheme is notified on 29/3 of 2022, my lords.
Where do I get
Do
that?
I share this, my lords? Some my lords
Yes, give it.
Yes. Lords, at page 1. May I read this, my lords?
Yes.
In exercise of powers conferred by subsections 1 and 2 of 151 capital A. My lords, may kindly take a pause here.
Yes.
This is issued not only in exercise of powers under subsection 1, it's also issued in exercise of powers under subsection 2, which enable the board to notify those sections which should not apply or should apply with such exceptions, modifications, and adaptations. Therefore, my lords, this would, to that extent, override those repugnant provisions of the Income Tax Act. Then, my lords, the central government hereby makes the following scheme, namely, this scheme may be called as e-assessment of income escaping assessment scheme 2022. It shall come into force with effect from the date of its publication in the official gazette. Then, my lords, definitions. Clause B may kindly be seen, my lords. Section 2(1)B, automated allocation, means an algorithm for randomized allocation of cases by using suitable technological tools, including artificial intelligence and machine learning, with a view to optimize the use of resources. That is how, my lords, the cases will get allocated. Then, my lords, the words and expressions used herein but not defined, but defined in the Act shall have the meaning respectively assigned to them in the Income Tax Act. Scope of the scheme, this is important, my lords. For the purposes of this scheme, there are two limbs there. A, assessment, reassessment, or recomputation under section 147 of the Act. B, issuance of notice under section 148 of the Act. Shall be through automated allocation in accordance with the RMS formulated by the board as referred to in section 148 of the Act for issuance of notice, comma, and in a phaseless manner to the extent provided in section 144B of the Act with reference to making assessment or reassessment of total income or loss of the assessee. My lords, there are two limbs, as my lords have seen in this notification. One, my lords, is assessment, reassessment, recomputation under section 147. Two, my lords, issuance of notice under section 148 of the Act. My lords, my first humble submission is, this notification is dated 29th of March of 2022. Whereas from 1st of April of 2022, the assessment, reassessment, and recomputation under section 147 has to be made under 144 capital B, which will start with a notwithstanding clause, non-obstante clause. Therefore, my lords, the scope of this notification may kindly be confined only to the second limb of it, that is issuance of
notice under section 148 of the Act. Yes.
My lords, section 147, which gives, my lords, room for doing reassessment, is subject to provisions of 148 to 152, which will inter alia include 151A as well, 148 as well. Therefore, my lords, the whole of reassessment as is coming in section 147 is subject to those sections as is stated in section 147,
inclusive of 151A,
up to which includes inter alia 151 capital A. Now 151 capital A, my lords, have found that the board is enabled to bring a scheme. The board has brought a scheme. The board has brought a scheme whereby, my lords, it says issuance of notice under section 148 shall be through automated allocation in accordance with RMS formulated by the board as referred to in section 148 for the issuance of notice, comma, and in a faceless manner. Therefore, my lords, it has to be necessarily by way of automated allocation, and it has to be necessarily by way of faceless manner. My lords, the parliament has used the word shall, the board has used the word shall here, my lords, which essentially indicates that there is no choice left to the revenue.
Mandatory.
It's mandatory, my lords. The Honorable Constitution Bench in Anjum Kasawala, my lords, in 252 ITR 1 has held that shall necessarily indicates the mandatory nature of it. Therefore, our first humble submission, my lords, is when the procedure is laid down none other than by the board which is at the helm of the affairs, it is incumbent upon, my lords, the executives who are to work under the instructions of the board to meticulously and rigorously follow the scheme. And when a procedure is laid down, which procedure, my lords, is not without the sanction of law, this is under 151A, notification has to be tabled before both the houses of the parliament, which will get, my lords, lot of validity. And therefore, my lords, this is a procedure which the board has drawn for itself in exercise of power under 151 capital A, and department has to live or die by this procedure. Therefore, this particular procedure cannot be deviated from, except it's up to the department to change the scheme as they so choose to do, as long as the procedure is laid in the scheme laws. It has to be meticulously followed. This has been, my lords, followed by most high courts, which, my lords, I'm sharing a compilation, my lords.
What is this compilation?
That compilation, my lords, is on the first principles.
All right.
Of what is shall, and when a procedure is laid, my lords, the department, in fact, in Sukhdev Singh's, my lords, the Constitution Bench
Para 175.
and 177.
Bhagat Ram, para 175. He who holds the sword of procedure
will perish by it.
Will abide by it or perish by it.
Exactly.
Para 175.
Exactly. So I would not trouble, my lords, with those.
7-judge bench.
And also one another interesting aspect there, my lords, is the parliamentary affairs. This compilation, my lords, first compilation, if my lords would kindly see, manual of parliamentary procedure also is enclosed, my lords, which will deal with page 13, my lords, in the first compilation.
Page 13.
Page 13, 13, my lords.
Yes, sir.
My lords, because section 151A subsection 3 would require it to be placed before both the houses of the parliament. What would happen in the parliament? Lords, the parliamentary procedure of placing these schemes before both the houses of the parliament, and they have the ability, my lords, to modify it if they so choose to do.
Yes.
And if they do not do anything, then only it would become binding. If they choose to modify, my lords, then it will apply in the modified form. Parliament in this case has chosen not to modify. Therefore, my lords, this will remain almost like part of an enactment, my lords. So typically, for normal notifications issued, this kind of a requirement would not be there, my lords. Only in special cases, my lords, in the Income Tax Act, it is provided that these notifications will have to be placed before both the houses of the parliament. Obviously, for the reason that, my lords, it will interfere with the rest of the provisions of the Income Tax Act. And therefore, my lords, the members of the parliament will have to be aware of it. Then, my lords, the second compilation, which my lords may kindly I would not trouble my lords with reading all these. My lords, the favorable decisions To start with, my lords, is the page 286, my lords. First case.
Telangana.
Telangana, my lords.
Shankar sir has relied on that.
This is Kankanala Ravindra Reddy
yes.
case. It's a batch of writ petitions, my lords. In this, it also consisted of those which were issued later on afresh, those which were earlier wrongly issued, set aside by the Honorable Supreme Court in Ashish Agarwal and later on reissued. It had the entire list of these matters, my lords. Then followed by next decision, my lords will find it at page 299. Hexaware Technologies versus ACIT, Bombay High Court decision,
Yes.
my lords. Then, my lords, Punjab and Haryana High Court decision in Jatinder Singh Bangu case, my lords, which is at page 344. Then, my lords, the Honorable Madras High Court decision in TVS Credit Services in page 354. Then, my lords, one more decision of Telangana High Court, my lords, in latest decision, Mallesh Gaud Donkeni, my lords, which is in page 362. Then, my lords, Rajasthan High Court decision in Sharda Devi Charger versus ITO at page 380, my lords. And, my lords, the Guwahati High Court decision in Ram Narayan Sa 424, my lords.
Yes.
And two SLPs, my lords, one emanating from Telangana High Court and
Yes.
one from Bombay High Court, my lords,
Yes.
which, my lords, will find it at page 428. Additional
As
Director
late
of Income
as
Tax,
late as 18th August.
as late as 18th August and 16th July, my lords. So, and, my lords, the Honorable Supreme Court in Rajiv Bansal at page 430, my lords, which in a different context stated that the jurisdictional conditions have to be meticulously followed. And if not followed, my lords, it will go to the root of it.
I have relied on that in that 148
Yes, yes,
judgment
yes.
last week I delivered.
Yes, my lords. So therefore, my lords, our humble submission, my lords, is that as it's been held by majority of the high courts, my lords, we would not say that there are no adverse decisions, but majority of the high courts of this country, my lords, has held that if this procedure is not followed, my lords, it will go to the root of it.
What are the adverse decisions?
Adverse decisions also have given, my lords. Serial number 11, my lords. Triton Overseas, Calcutta. Decision of the Honorable Single Judge, my lords. It did not, with extreme respect, my lords, did not go into these schemes. Just went in by some office memorandum, which is an internal communication. And therefore, our humble submission, my lords, is when there is a scheme led by the Central Board of Direct Taxes, which are the statutory force, an office memorandum, my lords, cannot override the scheme. So this honorable decision of Calcutta High Court, my lords, the learned single judge has decided this case solely on the basis of the office memorandum, therefore may require to be most kindly distinguished, my lords.
Ignored.
I would not say that, my lords. Most kindly to be distinguished, my lords. Then Sanghi Steel also is same, my lords. But then there are three high courts, Talati and Talati LLP versus ACIT, my lords. Gujarat High Court has taken an adverse view, my lords. And the Delhi High Court, my lords, in TKS Builders Private Limited, which I have given, my lords, at page 484
Yes.
and 495.
Yes.
And Kerala High Court, my lords.
That is 15 also.
15 also, my lords.
So these four,
My lords may kindly consider three decisions.
which is the
Talati, TKS, and
TKS, Talati and
Kerala High Court, my lords. Assam-
Calcutta High Court.
Calcutta High Court, my lords. they have
Calcutta High
gone-
Court, Gujarat High Court, Delhi High Court, Kerala High Court.
Calcutta High Court, my lords, is the
On the office
on
memorandum.
the office memorandum.
Others are on the statute
Others
itself.
are on the yes, my lords. Others are on this.
They are all the learned single judges,
No, they are division bench.
division bench.
Whereas the other decisions which are in favor of the assessee which have given, my lords, are all the division bench decisions.
No, this
These
adverse,
three, Talati and Talati, TKS Builders, and the Assamanur Service Cooperative are all division bench decisions.
are all division.
Yes, yes, my lords. I'll just confirm the last one, my lords.
No, that's
Yes.
single judge.
Yes.
Kerala is also single.
Yes, my lords. Kerala is also single, my lords.
His lordship is here with us now.
Yes.
Yes.
So therefore, my lords, the position is very clear. The mandate is very clear, my lords. And the revenue absolutely has no reason not to follow this. And my lords, the scheme has been brought in to introduce transparency, and scheme is mandatory. So when a scheme that has been mandatory and is brought in to introduce transparency, to deny certain assessees at their whims and fancy, my lords, this benefit of transparency itself would cause prejudice to those assessees. And my lords, next, my lords, is that reassessment is, my lords, disturbing a concluded assessment. It should not be ordinarily resorted to, my lords. The Honorable Supreme Court has said in Parshuram Pottery's case. And my lords, when the reassessment proceedings are
Reasons to believe.
Exactly, my lords. Reasons to believe cannot just be a pretense, my lords. Reasons to believe would be subjective satisfaction on the basis of objective tangible evidence. The Supreme Court in Kelvinator's case, my lords, 328 AR 561 has said that. Therefore, my lords, it's important for the Income Tax Department to meticulously follow it, and if they do not follow, my lords, they will have to face the consequences. And one submission, my lords, is that some of these writ petitions, my lords, there are other jurisdictional grounds as well. Those, my lords, if my lords are holding in favor of the petitioners.
No, there are two division bench judgments.
My lords.
One of Madras High Court and the other recently rendered Telangana. Both the division benches have held.
My lords.
One following the Telangana following the Madras High Court,
My lords.
saying we will dispose all these cases. Hold that it is violative of 151A. And in the event the apex court would hold otherwise, liberty is reserved to the revenue to revive all these cases.
Yes.
So,
And also, my lords, the liberty to the petitioners to
urge all
argue
other contentions.
all other contentions.
That is what the division bench of Madras and
Exactly.
Telangana have held.
Yes.
Close Marna. Illandre will have to write, you have no jurisdiction to deviate from 151A, or if you want 147, it shall be, or 144, it shall be in compliance with 147 to 152.
147, my lords.
147.
Which, my lords,
Just
just find
in
it at
reply.
page.
Not difficult to hold, but that is balanced order.
Just in
A
reply,
statute
my
is
lord,
in place. If a statute is in place that it should be only by a faceless manner, then how are you manually issuing notices? Because the statute itself indicates that the notice should emanate in a faceless manner. Because if notice should emanate in a faceless manner, as Chaitanya sir said, the algorithm selects someone, then it goes from notice emanates from that person, that area.
I'll just try to, my lord,
Heli Raviraj.
complete the procedure. My lord, the origin for the issuance of notice is section 130,
130.
51A, etc. Now, my lord, 130, the heading is faceless jurisdiction of income tax authorities.
Yes.
The central government may make a scheme by notification in the official gazette for the purpose of, my lord, then I'll skip all that, so as to impart greater efficiency,
Transparency and accountability.
by, so it is going to be done by eliminating the interface between the income tax authority and the SSC or other person to the extent technologically feasible. So I am emphasizing, my lord, the last 4 words as on today. Then, my lord,
Why your challenge technically?
not because my instructions are, my lord, 148 notices now is not issued, as it said, Vincent Fancilla, because every notice as on today is issued by the JAO. Because
jurisdictional officer.
Jurisdictional officer. I'll come to that, my lord, later. Because till now, my lord, I am told that they have not developed a system where 148 notice can be issued by the faceless. Till today, it has not.
So that is exactly the doubt that I generated on the other day. See, 148 notice is by the jurisdictional officer. Once you file the return of income in reply to that 148 notice, it then gets into faceless mode, or it generates in a faceless mode under 148.
My lord, I'll clarify, my lord, next 3.
I'll get back to this. Yes, I'll get back.
So as to impart greater efficiency, transparency and accountability by, I'm reading the 3, Introducing a team-based exercise of powers. This is important. Each word is important. Introducing a team-based exercise of powers and performance of functions by two or more income tax authorities. So it's not only two, not one or two, two or more income tax authorities concurrently in respect of any area, persons or classes of persons or income or class of income or cases or classes of cases with dynamic jurisdiction. Now, my lord, 4.78. My lord, they have introducing a team-based exercise of powers.
Yes.
My lord, that is told in my lord first point. Then, my lord, it says by exercised by two or more income tax authorities. How they will exercise the jurisdiction concurrently?
Now, all this is for the purpose of introduction of the scheme.
Please, please.
The government shall notice all this while introducing a scheme. What is the scheme?
Then, my lord,
Does it include two or more authorities, or it is only faceless? That is what is important.
I'll come to this.
Yes.
Then 151A.
Uh,
My lord, the central government may make a scheme by notification in the official gazette for the purpose of assessment, reassessment or recomputation under section 147 or issuance of notice under 148 or conducting of inquiries or issuance of show cause notice or passing of order under 148
yes.
or sanction for issue of notice under section 151
Yes.
so as to impart greater efficiency, transparency and accountability by eliminating the interface between the income tax authority and the SSC or the other person to the extent technologically feasible. That is one. Then again, my lord, see, introducing a team-based assessment, reassessment also is used, reassessment, recomputation or sanction of notice
with dynamic jurisdiction. Yes.
Then, my lord, I'll take my lordships to, because this 151 years is about faceless assessment of income escaping assessment. Now 144B.
Yes.
My lord, notwithstanding anything to the contrary contained in any other provisions of this act, the assessment, reassessment or recomputation under section 143(3) or under section 144 or under section 147 as the with respect to the cases referred to in subsection 2 shall be in a faceless manner as per the following procedures, namely. Then, my lord, skipping the pages. My lord, one, my lordship will find the notices issued under 143(3), 142, that is in 3, small 3. I have not been able to find the mention of 148 specifically in this.
Where are you reading?
I'm reading, my lord, 144B. My lordship may go to my lord.
So there is no mention of 148. So 148, it can be by the jurisdictional officer and not faceless is your submission. All right. Because 144B does not mention about 148.
And my lord,
now you tell me,
my lord, I'll just
148 can spring without 147?
No.
Then 147 is already here.
It is there.
Then why 148?
No, my endeavor is to convince my lordships that, my lord, both JAO has not been excluded specifically. He is not kept out.
No, see,
that is clear, my lord. If
faceless manner also you can do. Jurisdictional officer can do.
It's not that.
It will lead to chaos.
My lord, to the extent, my lord, all the cases, my lord, till the issuance of 148, it has been, my lord, through the system, my lord, the case is recognized. Then the case is sent to the jurisdictional officer. Jurisdictional officer will exercise his jurisdiction only to the extent of issuing the notice under 148A, asking for objections.
No, you come back. 147, in a faceless manner, the case is recognized. Under 148, the jurisdictional officer will issue a notice.
Till issuance
Correct.
of 148.
No, 148, the jurisdiction. See, 147 case is recognized in a faceless manner. 148, if the jurisdictional officer is permitted to issue, then face is recognized. That is the interaction between the assessee, and that is what is to be obliterated. Case is recognized as a face should not be recognized.
No, but it is issued, my lord, in the faceless manner.
Issued in the faceless manner, to be continued how?
To be continued by the JIO, my lord, in the faceless manner till the issuance of 148.
Where
My lord,
are
that
you-
is clear, my lord. My
Where are
lordship
you
will-
getting this from, sir?
My lord, my lordship will kindly go to my lord 144B 31.
31.
Common 31.
Yes, all right, one moment. 31.
After the issuance
National
of,
Faceless Assessment.
after the National Faceless Assessment Center shall, after the completion of assessment, transfer all the electronic records of the case to the assessing officer having jurisdiction over the said case.
So
The
according
assessing
to you-
officer never loses the jurisdiction.
So according to you, only the initiation is recognition of a case is by faceless manner. Further proceedings here is all in a manual way.
Till the issuance of 148.
Correct. After
After that, again, it
issuance
goes-
of 148,
it goes to
when
the
he files the return of income, it is before the, it is
Faceless.
in a manual mode before the jurisdiction officer.
Once the return is filed, it goes to the my lord faceless.
That is exactly. Where are you getting this person who is now wanting to interact with the assessee in the interregnum? Where is the provision? See, after filing return of income, if it goes to a faceless manner and notice emanates from a faceless manner, where is the human intervention?
My lord, harmonious reading of my lord 31. My lord,
Harmonious
because
reading.
It says having jurisdiction.
No. Harmonious reading should not do violence to the statute that you yourself have created. That's a procedure that you have adopted. You shall hold on or perish under that. Sir, procedure is the lifeblood of every system. Now, this is the system that you have adopted. Where is human intervention here? Tell me. Notice recognition ge it is faceless. For return of income file madadmele to proceed further it is faceless. Where is the jurisdictional officer issuing a notice? So according to you, recognition of a case for escaped assessment is by faceless. The notice under 148 is issued manually. After filing of the return of income, again it goes faceless. That is what you're saying?
Correct. My lord, I'll just give the small note, my lord, how it is practically done now. It is not pick and choose, my lord. All the cases are done like this.
No, if you have erred
And
in,
everything is done in faceless manner. Only, my lord,
no,
the
if you
jurisdiction.
have erred in one or if you erred in 1,000, error is error.
Yeah, please.
Yes. But let's see. So
I
that's
just
your
place- I may be
submission.
permitted to place a note, my lord, how the procedure is being done.
No problem. Yes. Sanmati.
Section 148, my lord. Section 148, when before making the assessment, reassessment or recomputation under section 147, the assessing officer shall, subject to the provisions of section 148A, issue a notice to the assessee along with a copy of the order passed under subsection 3 of 148A. Your lordship, here I
So
stop.
that is the earlier regime.
Sir, Your lordship, assessing officer. 148A also specifies regarding one assessing officer. In 148A, my lord, it is also mentioned where the assessing officer has information. Wherever, my lord, your lordship may carry 148A, my lord, clearly says, stipulates not one assessing officer. Who is assessing officer? It is defined in section, my lord.
No, that is of course.
Jurisdictional assessing officer. So there is no bar for the jurisdictional assessing officer to issue notice under section 148.
Then what have you achieved? Saying it should reduce interaction, promote transparency.
This final reassessment order is passed by the faceless, my lord. It is only the threshold, my lord. The jurisdictional AO issues the notice, and in response to that, the assessee files return of income. Then later on, subsequently the final order, my lord.
Notice faceless. Return of income by him. Two faceless. Proceedings faceless. Your argument is baseless. Yes.
My lord, for a minute, my lord, 148B8. I did not read, my lord.
The lighter
Subsection
way.
8,
Don't
notwithstanding,
mind Sanmati, sir. Yes.
notwithstanding anything contained in subsection 1 or 2, I am reading, my lord, 144B8. The principal chief commissioner or the principal director general, as the case may be, case may be in charge of National Faceless Assessment Center may, at any stage of the assessment, if considered necessary, transfer the case to the assessing officer having jurisdiction over such case with prior approval of the board. So what I am trying to, my lord, submit is, at no point of time the JAO is excluded. That is not the purpose of bringing this.
We'll see some food for thought from both of you. Yes. Sushal, you have something to say? Jagdish, oh, Neville, tax. Yes, sir.
I think, my lord, I just want to take your lordship to all these matters have been looked into by the decision of the Bombay High Court in the case.
Exaware.
No, Exaware, Abhin Anil Kumar Shah, which I took. Page 190, my lord, of my compilation.
What Shah?
Abhin Anil Kumar Shah.
Our madam.
Compilation.
Shankar sir, compilation. Yes.
The lordship will notice.
Adral page?
Page number 190 is starting of the judgment. And the notifications are all from para 8 onwards.
190. Yes.
0, 197. And the relevant notification is at 200.
This I've marked it already.
Yes. I read it. And para 12 is very, very important.
The same submission is made there.
Yes, my lord. Whatever the point para 12, ultimately my friend Chaitanya added one very interesting and important supplement to all that I argued. In as much as he said, once this notification is placed in Parliament, it partakes the character of an act.
Correct.
Now, they cannot now say that issuance of notice under 148 shall be through automated allocation in accordance with the risk management for issuance of notice and in a faceless manner. Categorical, they are saying. And your lordship at para 12, all their arguments are countered and ultimately held. And that's where they have method by which to balance equities. I placed before lordship the decision of the Madras High Court.
Correct. Madras and Telangana.
And in fact, Telangana has now issued one more recently. One more has come on same lines.
Daily orders.
Daily orders. That was on Southern Power.
Yes, Raviraj. If all of you say, we will pass that order.
That's all. Madras High Court order is, in my opinion.
Or if you want me to answer on merits, I will answer. But it is safe,
please,
to pass that order.
It is safe, my lord. Basically, because both equities are protected. My lord, the point is that ultimately, what is the object of them keeping it pending? Don't want multiplicity of litigation. Ultimately, your lordship have to take one view. If your lordship have to take, for example, a view in favor of the revenue, then each of the petitions have to be argued in respect of all other contentions.
That's all other issues that you have projected apart from faceless
will be kept open.
Will be kept open to be urged once the apex court decides on faceless.
My submission, my lord, is in your lordship have to ultimately hear completely in very great detail like other on merits and come to the conclusion.
Same conclusion.
Same conclusion or opposite conclusion. Then your lordship have to hear each petition on all other content.
Yes, that is true.
I'm saying that.
No, we will hold it later.
We will hold it
at a later point in time
the
to
Bombay
urge.
Court has taken all. Ultimately, my lord, they can't go against their own notification. How can the notification say that it is right and wrong? They have followed a notification.
Let's say because there are some high courts who have held in what terms the Council for the Revenue also is saying.
My lord.
And some high courts have not taken note, declined to accept.
The edition which I placed now, Telangana, actually takes into account both Talati and TKS buildings.
Correct, both, yes.
The one which I placed now, my lord.
They are now e-quotida.
They have noticed
the King's Pride.
King's Pride. Lordship will notice it at page.
King's Pride is in quite detail.
Detail, my lord. See, basically, Telangana is following Kanakala Reddy. So basically, the point is, my lord, every time a decision in favor comes, it is probably placed before the court. The effective thing, equity is basically the Madras.
Shall we do that?
Please.
Yes, Raviraj, Dilip. Yellaru okay. Neevu matra.
Dilip is.
Satyanarayana, Suryanarayana sir. Yes.
They say since we have already taken a view, we have followed that. But really, Lord's kindly see the single latest order in Madras.
That is against the SSC?
No, that's in favor of the SC. Although there was another view taken by a single judge of the Madras High Court earlier. Another different single judge takes a view in favor of the SC, distinguishing the Delhi High Court judgment in great detail. My lords may kindly see that.
Which one? Page,
It
which
is there
one?
at page 379 of my compilation.
379.
Yes, please.
And in that, para 5.3.1 of
No, no. TKS Builders is 379. Which do you want?
TVS.
Ah,
No, I did.
379.
No, it is not there, my lord.
TK, that is Delhi High Court.
No, that is not one. He's talking.
TVS, that's where my learned friend, Mr. Chaitanya has come.
No, my lord. Let me clarify. The one of TVS which I have given in my compilation is
TVS
the
Credit
decision of the-
Services.
Decision of the Honorable Division Bench.
Yes.
What learned friend Surya is mentioning is about this learned single judges case,
Adyavad Kotila.
which was upheld in the learned division bench. That is why I have given only.
That is again TVS Credit Services.
Yes, same.
That's why very short order, but in my lord, can you see paragraph 5.3.1 of this statement?
5.3.1. Yes, sir. Scope of assessment. Yes, sir.
Dissection of proceedings relating to assessment of escape income reassessment into two parts.
Yes.
The first part relating to assessment being until orders are passed under section 148A and corresponding issuance of notice under 148 of the Act. The second part being post issuance of notice under section 148 of the Act, commencing with issuance of notice under 142 and or 142 of the Act. While the first part is to be carried out performed by the JO, second part of the assessment must be by FAO. This dissection appears to be artificial. The above view also appears to be in conflict with the judgments of the Honorable Supreme Court, wherein assessment has been held to be comprehensive and would encompass the entire gamut of proceedings, starting from the filing of returns or issuance of notice and ending with the determination of the tax payable by the SC. Importantly, in auto and metal engineers, the Supreme Court is also known. Then, my lords, kindly see para 5.3. It does appear that proceedings for assessment would commence with initiation of proceedings under 148A of the Act, and as much as the notice is preceded by an inquiry with respect to information which suggests income chargeable to tax as escape assessment. In other words, proceedings under section 148A of the Act itself could be invoked only when there is information which suggests that income chargeable to tax as escape assessment is thus an integral part of reassessment assessment of escape income, and any attempt to treat it as distinct or removed from reassessment would only result in distorting the scheme relating to reassessment assessment of escape income. This would be clear if we bear in mind that 148A of the Act was inserted with a view to legislatively incorporate the procedure later in GK infraction. The dissection of the reassessment proceedings into two parts appear to be in conflict with the judgment of the Honorable Supreme Court on assessment being comprehensive and expansive, to take within its fold all proceedings relating thereto. Because that's what my learned friend's argument driven for that some part will be done by JO, some part will be done.
No, that
by
is what, yes.
That is not permissible. And not ultimately, because another learned single judge had taken a different view, the matter was referred to a larger bench, and the larger bench in
That is TVS Credits again.
Excellent, because one of the judges was the same judge in Excellent.
Yes, that's what. That is TVS Credit Services, Madras High Court. Justice Sriram was.
Yeah, Justice Sriram.
Yes.
It is a very detailed judgment as to why, because all the decisions which are in favor of the regulation, the high courts have said there is concurrent jurisdiction. That cannot be is what has been explained in this judgment of Madras High Court, the learned single judge. We cannot kindly see that.
So you want me to answer on merit? We will answer, no problem.
Yeah, I'm just saying that this is, it has dealt with in details. And thereafter came the division bench where in Dada Pharma and the other districts, where they have reserved liberty to raise other issues. And
No, as is, if you want me to dispose it, following the other two orders, keeping everything open and not going through the rigmarole of hearing each case, that I'll pass that order.
That would be.
Otherwise, this will be languishing here.
No.
Yes.
Yeah.
My lords, only for completion, my lords, at page 363.
Whose compilation?
My lords, senior counsel.
Shankar sir or-
Please.
one more aspect of before. some of these cases, I'm sure there are notices issued by the proceedings are the central or the international tax. I'm not sure whether international tax is there, although in the 6 cases I am appearing, neither of these issues are there. But the Bombay High Court has taken a view that this.
In those cases, without exception, my lords.
Without exception, whether it is central charges or international tax, if notice is not issued by.
Faceless.
Then it is.
Nimden,
There's only one submission, only for completion, my lords, page 363, my lords, Bombay High Court.
in whose compilation?
My lords, Senior
Shankar sir
Counsel
or
A.
Chaitanya sir?
Shankar sir.
Ah.
Let's, page 365, para 5. My lords, this is the order which has been passed. I'm only bringing it to your lordship's notice, my lords.
Exaware is followed.
My lords, what is that? Subsequently, it says, para 5, my lords, may read.
I am there in such circumstances.
In our opinion, in the interest of the parties, that henceforth we need to have a different approach, considering that in disposing of such petitions following exaware, it would involve both revenue as well as assessee to face further proceedings, for the reason that our orders in such manner create further litigation between the revenue and assessee. We may observe that the endeavor of the court would always be that at least the orders passed by the court ought not to generate. Lords, at page 365, Lords.
I'm there, I saw it.
Only that para I want.
Division bench.
Please, Lords.
No problem. I'll answer it on merits then.
Not on merits, my lords. If your lordships are reserving liberty, my lords.
You are blowing hot and cold, sir.
I'm only bringing it to your lordship's notice.
I have put all the decisions that made.
Yes.
Both
yes.
far and
May
against.
kindly reserve liberty, my lords.
So that is always there. What the division bench has said, that order I will pass.
Please.
In fact, the Madras High Court in Dada Pharma is actually, though very concise, very.
I think it's beneficial to all of you.
I explained also lot.
Exactly.
In a very lighter vein, I explained lordship why it is beneficial to everybody, including my friends.
Hello, that's what.
I have only one.
Well, by way of memo, Miller. Not by application or review petition, Miller.
We will observe all.
My only last request, my lord, individual orders may be passed.
If I'm passing, it is individual only. Individual. Ella dispose more.
Lordship can, one main case your lordship can dispose.
Ade, I'll take two main cases. One, three. Nimdi yavdu Suran sir. ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್ 282 283 ಅದ್ರಲ್ಲಿ ಒಂದು ಹೇಳಿ which do you like?
Issue all is JOFA only one thing.
345 345 yes ಅಲ್ಲ ಜಾಸ್ತಿ ಆಗೋಗ್ಬಿಟ್ಟಿದೆ. It's a legal ground, don't worry. Yes, legal ground. Even if you don't raise certiorari, yes.
My lords, few matters.
Now, one nimisha. I'll complete our. Chaitanya sir, nimdi yav.
Lords, in my case, I have about
I have-
8.
I have
But
a-
my lords may kindly take
No, I am holding 288.
288, my lords.
Your lead case will be 288.
Yes, yes.
Then Shankar sir,
Shankar sir.
403.
403.
403. Surnaran sir, ಬರ್ಕೊಂಡಿದ್ದಾರೆ madam. So these three cases will be the main cases. All else will follow, but they are individual orders. Yes.
Lords, on delinking, may I mention now?
Which is the delinking, sir?
Lord, one before.
Yes, yes, sir.
Treat for the assistance of the court, I made a compilation of all our matters.
ಕೊಡಿ.
It will help you a lot.
ಇನ್ನೂ ಇದೆಯಾ?
Please, my lords. There, inna ಇದೆ.
What is there in the list only? Some items have not come in the list. I just passed an order, what is the impugned order and things like that. Just is purely for the assistance of the court. My lord. It pertains to matters where I am representing.
Wait. I'll give this one.
So that it.
Shankar sir, in every case, we will quote the prayer and then follow these lead cases and the same order, so that each quoting may not prayer and this would be the manner in which.
My lord, two things may ultimately arise, my lord. One is quashing the 148 notice.
Yes.
And the consequential proceeding, because in some cases.
Obviously, consequential proceedings will have to go. See, the trigger point is 148 notice. If that is found to be erroneous, all consequential action will definitely go.
That is precisely-
Reserving liberty to them in terms of the division bench judgments. Yes.
Because that's the only case, this is the only issue.
398. All, so we'll take this as disposed. I'll write pass a detailed order and by next week we'll release it.
327 may be detailed.
320, learned senior counsel submits 327 only.
Interim orders may be continued.
Yes, 327, dealing 327, the interim order subsisting shall continue till the next date of hearing. Yes. I recommend. 1 minute.
Some items are not. This list.
Now, what are the other matters in the list which is faceless?
158.
In the B group there are some matters. Give those numbers, and other than the 230 list, if there are any other matters faceless, give those numbers as well. These three will be the lead. Yes, revenue councils. 357 dealing.
329, my lord.
Dealing numbers kodi. The dealing madadu, just give the numbers. Interim orders will continue. Yes.
Only one, 389.
Dealing. All right. Dealing. No. Whatever is to be dealing, write and give it to the court officer. It will be dealing, and interim orders will continue till the next date, if it is there. Yes.
We have moved 2 matters in the morning relating to the same issue.
In which?
Today's list.
That will be.
It is not in the list. We made a mention that will be.
We'll get them, don't worry. Yes. No, if it is not listed today, we'll have it listed on Saturday or Monday and close it. Yes.
Serial number 138, my lord. It was listed in the morning. Morning it was there in the list, my lord. Same identical issue.
Pass over madideni. Also disposed.
Yes, my lord. Serial number 138.
Yes, sir.
Similarly, 158 and 262 also.
All which are passed over. Yes.
On this account.
Faceless. So we'll take everything as disposed in this manner. Give me 5-7 days. We'll release the order. Yes.
Right.
Yes. We'll consider all. We'll note all the submissions. Not 2-page order. Yes.
On submission, my lord.
Yes, Sandeep.
That's 157, my lords, in the list today. That is also
Faceless.
a part of the. Yes, faceless also.
That also will go with 150?
7.
Yes,
157.
Other items which are not been listed.
Not.
What is not listed, will give it.
Not listed. Give the list, sir. I'll have them listed on Monday.
Yes.
Fourth. But 157, if it is faceless, we will dispose it.
Please.
Fourth beka. Ivattagadu, avattagadu.
Ivatta.
Yes. Avattagadu, ivatte maana. Yes.
Malaj, in
Yes.
few matters, Malaj, they've challenged constitutional validity. Malaj.
Of?
Malaj, 148.
Adi yavdu?
The explanation, Malaj.
No, constitutional validity is not challenged in any of the cases.
Malaj, in few matters they've challenged.
Some of the matters challenged.
That also will be kept open.
That, Malaj, your lordship's.
That also. No, I will not say they've given up. It will be kept open.
Everything kept up.
Later on, if the apex court would hold otherwise, then yes. And all this, ಎಲ್ಲ ಯಾವ್ಯಾವ್ದ್ರಲ್ಲಿ ಯಾರ್ಯಾರು ಅಂತ ನೀವೇ ಡಿವೈಡ್ ಮಾಡಿ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. ಕಾಲ್ ಲಿಸ್ಟ್ ಇದೆಯಾ? All of you will get. Yes.
Please.
Vijay. Now continue the list. Huh? D-link 18th ಆಗ್ಬಿಡಿ 18th.
Let's continue. Admission 167.
Yes, Jagdish sir. Nim jurisdiction bantu. Private matter.
Yes, 138, recall application. Recall application.
ಯಾಕೆ recalling already order ಆಗೋಗಿತ್ತು ಅಂತ.
It's like 311 application. I just saw on 311 application.
Correct.
The matter before trial court matter is still pending.
List the matter next Friday. Sorry, next Friday ಅಲ್ಲ, on 8th.
168.
ಇದರಲ್ಲಿ ನೀವಿದ್ದೀರಾ.
304A, 279, 327. Charges have been framed on 11/2/2025.
11/2/2025. Petition is preferred on 24th June 25. The learned additional SPP on instructions would submit that the subject petition is preferred on 24th June 2025 and long after the concerned court has framed charges and is proceeding in the matter. In the light of the judgment of the apex court in the case of Meenakshi Bala, so and so, the petition would not become entertainable once the charges have been framed and the trial is set into motion. In that light, petition is disposed, reserving liberty to the petitioner to urge all the contentions urged before this court, before the concerned court at the appropriate time and at the appropriate stage, ordered according. Next.
169.
498.
498 ena.
The 8 accused.
Husband?
Husband is also.
Petition pay for 2 days time lapse.
ಯಾರು ನಿಮ್ದ?
Plus ನಮ್ಮ ಅರುಣ್ ಕುಮಾರ್ ಅಂತ.
ಅರುಣ್ ಕುಮಾರ್ದ? ವೈ?
ಅವರು ಅವಾಗಿಂದ ವೇಟ್ ಮಾಡ್ತಾವ್ರೆ, ಎಲ್ಲ ಹೋದ್ರು.
Rest on Monday, 1st September.
170.
Execution. Emergent notice to the respondent returnable by the 18th of September. List on, sorry, 19th of September, list on 19th. Next.
171.
Emergent notice returnable by 18th, 19th, list on 19th.
172.
Appearing for respond.
Suit for?
Suit for proxy counsel.
Proxy counsel. Why did you come? I'll grant stay now.
Senior counsel out of station.
The petitioner is before this court calling in question an order of the concerned court dated 28/2/2025 by which the application filed by the petitioner defendant comes to be rejected under Order 7, Rule 11, A and D of the CPC. The concerned court, though, notices that the sale deed that is sought, notices that the suit is for declaration to declare the sale deed dated 19/5/2010 and 18/5/2013, 2013 as null and void, and the petition and the suit is instituted in the year 2022, has rejected the application. Prima facie, the rejection of the application appears to be in error. In that light, further proceedings before the concerned court shall remain stayed till the next date.
Appeal for petition.
ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್?
72.
172 ನಾ? ಹೀಗಾಗಿ 2 ನಾ ಮೇಡಮ್? ಎಸ್.
Time is granted for 2
Huh?
months. Senior counsel engage ಮಾಡಿದ್ರು.
ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಂಗೇಜ್ ಮಾಡಿದ್ದೀರಾ? ಎಸ್, ನೆಕ್ಸ್ಟ್.
173.
My lord, my colleague has filed a wakalat.
ಅವ್ರ ಹೆಸರೇನು? ವಾಟ್ ಇಸ್ ಯರ್ ನೇಮ್? ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್. You're not the advocate on record? Proxy counsel? You're a proxy counsel? Huh?
Senior counsel.
ನಿಮ್ಮ ಆಫೀಸ ಅಲ್ವಾ ಹೇಳಿ ಸರ್? ಮತ್ತೆ ನೀವು ಅದೇ ಆಫೀಸ್ಲಿ ಇದ್ದೀರಾ, ಮತ್ತೆ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಅಂತ ಯಾಕಂತೀರಾ? ಹರ್ಡ್ ಸೋನ್ಸ್ ಅಂತ ಮಾಡಿ ಮೇಡಮ್, ಅವ್ರ ಹೆಸರು ಹಾಕಿ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
173.
My lord, but I appear for the respondent, but this CRP is not maintainable. But your lordship, in a connected matter, there is an interim order, there are other matters also. That CRP is not maintainable under 115 of CPC as well as the 8 and there is no final order at all. My lord, if your
ಫೈನಲ್
lordship
ಆರ್ಡರ್ ರಿಗಾರ್ಡಿಂಗ್ ವಾಟ್ ಸರ್?
my lord, the
ಅಪ್ಲಿಕೇಶನ್ ಡಿಸೈಡ್ ಮಾಡಿಲ್ವಾ ಇನ್ನು?
ಇಲ್ಲ ಡಿಸೈಡ್ ಮಾಡ್ಲಿಲ್ಲ, ಎವಿಡೆನ್ಸ್ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರೆ. your lordship may kindly see the impugned order at
ಒಂದ್ ನಿಮಿಷ,
page 22.
ಐ ಥಿಂಕ್ ಪೆಟಿಷನ್ ಅವ್ರದ್ದು, ಒಂದ್ ನಿಮಿಷ ತಡಿ.
My lord, I had filed one application under section 16 of the Small Causes Act for return of the plaint, my lord. And the honorable court has rejected my prayer, my lord. Thereafter, I filed the CRP before this honorable court. On earlier occasion, my lord,
Is maintainable.
Your lordship, the page 44 may be order may kindly be seen. My lord, I think I'll, anyway, I am aware of it. There are other matter also. Your lordship connected matter, interim order was granted, it is posted on 19. I may able to.
I will post it on the same day. Tag this petition along with heard the learned counsel Gautam Dev Ullal and Prakash Shetty appearing for the.
There are other 7 matters.
Kodi sir ella appearing for the respondent. List the matter on 19th. The learned counsel for the petitioner submits the companion petitions. The interim order, impugned orders have been stayed. In that light, there shall be an interim order of stay in the case at hand as well. List on 19th. Vantala?
I think there are several other matters.
Give the list, my lord.
ಅವರು 7 others ಅಂದ್ರು, ನೀವು several others ಅಂದ್ರೆ ಕೊಡಿ ಅದನ್ನು.
ಅಲ್ಲ ಅದು ತಂದ್ರಿಲ್ಲ, 7 ಇದ್ರು ಸಾಕು.
ಸಾಕಾ? ಬಿಡಿ ಮತ್ತೆ ಕೊಡಿ.
Anyway, 10 ಇದೆ, 10 ಇದೆ, ಒಟ್ಟು 10
10
matter
ಅಂದ್ರೆ
ಇದೆ.
ಇವಾಗ
ಅವ್ರು 10 ಕೊಟ್ಟಿದ್ದಾರೆ ಬಿಡಿ.
ಅಲ್ಲ 3 ಆಯ್ತು. ಒಂದು ಫಸ್ಟ್ ಕೇಸ್, now 2 cases, my lord. Before
ಇದು 2 ಇದೆಯಾ ಇಲ್ಲಿ?
my lord, another serial number 197.
ಆಯ್ತು. Tag all these.
Yes, tag on. My lord, I will make my submission on merit that.
19th.
ಅಲ್ಲಲ್ಲ 19ಕ್ಕೆ ಮಾಡ್ತೇನೆ. But the actually, my lord, the CRP is not maintainable at all.
ಅದೇ ಅವತ್ತು 19th ಕೇಳೋಣ.
ಮಾಡೋಣ.
ಅವತ್ತೇ ಮಾಡುವ.
Because there are 10, because other matter, they also have disposed of on merit.